Welcome. My name is Gerald Newman. I'm a professor here and the director of the Human Rights Program. And it's my immense privilege and pleasure to be able to introduce to you today Professor Martti Koskenniemi, who is the foremost theorist of international law today, as well as a distinguished practitioner and esteemed teacher. He's well known to people who study in the field, including from some famous books, Between Apology and Utopia, The Gentle Civilizer of Nations, and more recently, To the Uttermost Parts of the Earth. As I guess you can tell from the titles, he's also a skillful stylist, and I'll say a bit of an ironist. And he's also very well known for the famous work that he did with the International Law Commission on fragmentation of international law. He's going to be speaking today about powers of sovereignty, powers of paradox. And there'll be time for some questions at the end. Please be aware that this session is being streamed. So don't speak if you don't want to be seen outside the room. I'm grateful to our co-sponsors for the event, including the Program on Law and Society in the Muslim World, the Harvard International Law Journal, the Harvard European Law Association, and the Institute for Global Law and Policy. So please join me in welcoming Professor Koskenniemi.
Hello. I'm happy to be here. I've been now at Harvard for 2 months. I've met a lot of students. I see some of you who I've met here, not all, obviously. It's been quite a busy 2 months. I've done a lot of talks, seminars, etc. This is a privileged place, obviously, to do that sort of thing. Thank you, Gary, for that introduction. The topic is on the powers of sovereignty, powers of a paradox. It's based on an article. The article is a commentary, it's a published article, it's a commentary on several other people speaking on sovereignty from their various disciplines. But it's also a commentary by someone who, as an international lawyer, has for a number of decades already had to do with the issue of sovereignty, the difficulties of dealing with, and an effort to try to articulate one sense in which that elusive concept can be harnessed, if not harnessed, at least in somehow dealt with. So sovereignty persists despite all the critiques by human rights people, by populists, by globalists of all kinds, and so on. There's a great difficulty of getting rid of it from the international law side. Some people say that international law was born in the late 19th century from sovereignty. I rather want to say it was born out of a critique of sovereignty. So the early international lawyers were always trying to put forward a critique of sovereignty over which the purported rules and institutions would then take up their place. In domestic societies, we constantly, at least we in Europe, I know that you in the United States also, confront sovereignty. When my country, Finland, became a member of the European Union, there were voices saying, oh no, we'll be giving up our sovereignty. And then I was at the foreign ministry at the time, or still a diplomat at the time, and we were told to respond to those people, those mostly right-wing critics of the idea of integration that, no, we are not giving up sovereignty. We are realizing our sovereignty by being able to join the European Union. And so that's one of the first points which I want to make come across as a paradoxical issue. It's true that you can critique integration by reference to holding on to national sovereignty, but you can also justify integration as a powerful act of national sovereignty. Sovereignty, I want to put forward to you, is a limit concept. It's a concept of excess. It's a concept which somehow, in the various contexts where we encounter it, pushes beyond the limits of routine ways of dealing whatever it is that we want to deal with. It pushes beyond the limits of specific vocabularies, of specific ideologies, of specific approaches, especially disciplinary approaches. And what I'm going to sketch to you is a kind of a series of references or deferrals, if you wish, from one vocabulary where sovereignty, where we use sovereignty, to other vocabularies that then seek to explain why it is that we use sovereignty in that prior vocabulary in the paradoxical ways that we do. At the heart of the notion is a distinction between routine and something that's not routine, exceptional. As lawyers, we are familiar, maybe some of us are familiar with the interwar debates especially in Germany, concerning the nature of German sovereignty in a number of situations. One of the debates juxtaposed the two famous lawyers, Carl Schmitt and Hans Kelsen. When Schmitt, a right-wing lawyer, wanted to defend the powers of the German chancellor over the constitution, he did that by putting forward a response to the question, where does sovereignty lie? That sovereignty is the sovereign is the one who can decide on the exception. The idea, Schmitt's idea being that the constitution and the legal order must always rely on something beyond itself. It cannot just rely on itself like Münchhausen, raise itself from its hair. It must find from the outside some power that guarantees the effectiveness of it, and which in that sense is somehow more important, more significant than it, the guarantor of it. And he saw the German chancellor in that position. And Hans Kelsen, as a liberal social democrat legalist, said, no. The constitution guarantees its own power. And those of you who've read Kelsen, as I did once upon a time in my first year at law school, I had no idea what this was about. So you know that Hans Kelsen's idea of law consists of a series of validations in a hierarchical order, so that the command of the policeman is validated by the municipal order is validated by the legislation endowing it, the legislation is validated by the constitution, and then comes the question of sovereignty. What guarantees the constitution? And Kelsen responds, the constitution guarantees itself through what he calls in his Kantian language, a transcendental hypothesis, meaning thereby that the guarantee that we must presume the validity of the constitution in order to explain why it is that we know everything else that we know about the legal order. If we don't know that the legal order is valid, then we don't know these practical things that when there's a ticket when we get a parking ticket, we must pay it. When there's a law and that we have broken, we must pay a fine or go to prison, etc. So a really complex response, a kind of Münchhausen type of response. So which is right? This debate between Kelsen and Schmidt about where is the sovereign in the legal order may be analogized with other debates that were going on in the interwar. For example, the debate launched by the Austrian mathematician Kurt Gödel, when he suggested that mathematics cannot prove all the true statements that contain in mathematics, or that systems theory, when it explains to us that no system can exhaustively explain its own conditions of validity. Those conditions of validity must, to some extent at least, be outside the system, so that the system must be going. And some of you will recognize a logical set of positions here. The rules of logic must come from elsewhere than logic. So I suggest to you that sovereignty has some of that quality. It pushes towards some boundary in a discipline and tries to respond to the question, why do we believe these things that we believe we know that are there truly and efficiently in that discipline itself? And I want to go through a series of disciplinary referrals that I see take place. The debates often on sovereignty concentrate on history, and they point to this Frenchman Jean Bodin in the 16th century lawyer, in whose book, the six books on the concept of sovereignty, he put forward a powerful idea of modern sovereignty. Historians say sovereignty as the absolute and perpetual power of the ruler. Absolute and perpetual power. Nevertheless, when we read the 6 books on the Republic, his book, we notice that actually, having said that sovereignty is absolute and perpetual, Bodin continues by saying that it doesn't at all mean that the ruler would be freed from the rules of natural law and divine law, for example. So the ruler's authority is still guaranteed or endowed by something outside ruling itself, namely in natural law or divine law. James I of the Stuart family in the early 17th century, a famous absolutist ruler in whom the idea of sovereignty is somehow personified often, in his The True Law of Free Monarchies, puts forward also an idea of an absolutist ruler. And having said that the ruler has absolute power, points out that, well, it doesn't mean that the ruler can whatever. Obviously, the ruler must treat his subjects as a father would treat their children, as any parent here knows, fathers and mothers' powers are anything but absolute. So again, even at the moment of the height of absolutism, early 17th century, when the very notion historically of sovereignty is born, it's born both as absolute and perpetual, and at the same time, something less than absolute and perpetual. When Louis XIV famously, apocryphically, but famously, one day may have thought, l'État, c'est moi. At that very moment, which we think of as the peak of sovereign power, of absolutism, a correct response to the question, what is France, would have pointed to the 50,000 venal office holders. That is to say, men who had bought their way into French office and owned that office as private property, owned it to the extent that their sons could inherit it. Louis couldn't lift a finger without the ruling families in the French realm that provided for the finances for his endless wars would have, without them consenting to whatever it was that he did. Again, we see sovereignty in its Baroque manifestation in Louis XIV, and something beyond that sovereign, which exists outside it. And the problematique of sovereignty inquires into that separation, that gap between the holder and something beyond there. Now, Hugo Grotius, also obviously in his De Jure Belli ac Pacis 1625, deals with sovereignty. He makes a distinction between what he calls common sovereignty and proper sovereignty. Common sovereignty is what the people have, or had actually, because they had it when they made the contract to build the state, and then they granted it to the ruler, who has what Grotius calls proper sovereignty. But Grotius also said, now you have to remember that Grotius was an important political operator and a lawyer at the time when the United Provinces, the Netherlands, had just undergone a rebellion against the Habsburg monarchy, and the 7 provinces of the United Provinces set up a republic in which each one of those 7 provinces hated the idea that any one of them, and especially Holland, would have taken a superior position. So Grotius also said that sovereignty, unlike Baudin had suggested, can easily be divided. And in the case of the United Provinces, he wrote, it's divided between the 7 provinces. So it seems that in order to understand sovereignty, we cannot just rely on history, because if sovereignty can be divided between people, between provinces, it's all a question of the juridical rules that then divide it or allocate it, or some parts of it, to some different groups of people. And I move from history to the juridical sphere. In the international legal field, that question was at the heart of the Austro-German Customs Union case in 1933. Many of you may know of the Austro-German Customs Union case. So after the First World War, Austria, as part of the peace deal with the Allies, had conducted the Treaty of Saint-Germain, 1921-22. In the Treaty of Saint-Germain, Austria had promised not to alienate its sovereignty. The point on the Allies side was to guarantee that Austria would not try to merge with Germany, and so that there would be this dangerous and powerful German-speaking center in Europe. Austria and Germany had to be kept together. And so Austria promised not to alienate its sovereignty. Now, immediately after having promised that, Austrians and the Germans started to prepare a customs union in Germany. And by 1933, the customs union, or actually by 1931, the customs union plan was ready, and the Allies were outraged. What do you mean, customs union? You had promised not to alienate your sovereignty. The Allies took the Austrians to the Permanent Court of International Justice, the predecessor of the present International Court of Justice, and accused Austria of having violated its sovereignty by engaging in this customs union. And the Austrian lawyers at the court, perhaps predictably, answered, well, if Austria is unable to conclude a customs union treaty, then Austria is not really sovereign, is it? So we can see here the same paradox as in these debates on integration today, European Union, or about international law and international human rights in general. The debate in the UK nowadays about the Human Rights Act and about the UK being bound by the European Convention on Human Rights constantly raises those arguments. There are members in the British political elite who say that British membership in the European Convention is a violation of British sovereignty. The fact of Britain being bound by the decisions of the European Court in Strasbourg is a violation of sovereignty. And other lawyers say, no, we joined it as an act of sovereignty. And as a fact, we, the Brits, were quite crucial in once upon a time drafting the convention itself. So it seems really hard to find a legal meaning for sovereignty. If sovereignty can be accommodated both with a situation of a state living in hermetic isolation, with no obligations to anybody, as well as a state that has completely given up all of its powers, privileges, rights to an international body. So it doesn't seem to have much of a sociological sense, does it? Well, this is what the lawyers said from the outset. Bartolus of Saxoferrato, the famous 14th century Roman lawyer, was faced with this problem. He was called upon and ideologically predisposed to defend the powers, the supreme powers of the North Italian city-states, Florence, Milan, the Papal States, and so on. But he was also called upon to affirm the powers of the Holy Roman Empire, and under Roman law to deny the powers of empire. And you remember the Roman law was enacted by Emperor Justinian, a Christian prince. To deny the powers of the emperor would have been heresy. So Bartolus did what all lawyers at legal places of legal education, such as this, learn to do. He made a distinction. He made a distinction between sovereignty de jure and sovereignty de facto. And he said, of course, the emperor is sovereign de jure, and the city-states are sovereign de facto. Okay. So this seems to indicate that instead of being a juridical question, it's a factual question, it's a sociological question. And of course, there's been many people who have suggested precisely that. Sovereignty has to do with who has the power to uphold the order that exists. That's the Carl Schmitt point. And the point has been made in the past many times within the Ragion di Stato tradition by Machiavelli, Giovanni Botero, other people. And they have said, well, sovereignty is really, they don't have this vocabulary, but had they had it, they would have used it, is really a sociological question. It's a question about who has principal power. It's a question of strength. Now, in the 17th and 18th century, many people, especially in the diplomatic and in the law of nations debates, shared that view, a political realist view, you might say, that sovereignty has to do with efficient power. In the 18th century, lawyers and political operators started to think more deeply about, well, what is the basis of the efficient power in a public realm, such as state? And increasingly, they started to look at the ability of the state to produce the welfare of its population, as well as the security of its own realm, which meant that engaging in mercantilist activities seemed to be extremely important. However, in the latter part of the 18th century, a group of lawyers and political operators started increasingly to think that the power of statehood is actually not just how much finances there is in the fiscus, but how well the the civil society and the commercial order enshrined within the civil society operates, so that the civil society as a whole, its strength is the measure of the strength of the power as well, in which case the sovereignty is diluted into the discourse and set of competencies in the world of commerce and trade and commerce. The Enlightenment universities in Germany, Halle, Göttingen, the lawyers started to develop a Polizeiwissenschaft, policy science, that examined precisely the conditions of effective policymaking in the state, and came to the conclusion that effective policymaking required a well-functioning capitalist economy. Now, does this mean then that a well-functioning capitalist economy is the sovereign and is the discipline of economics, the discipline within which sovereignty can be decided? Well, there were also many people who thought that you cannot just think of sovereignty in terms of where effective power lies. You also have to ask the question as to what the effective power is intending to achieve in society, about the normative structure that characterizes the effective power. Sovereignty must be different from a mafia regime. And then, of course, Western liberal jurisprudence, starting from Immanuel Kant, going to HLA Hart, etc., the internal aspect of the rule, the gunman problem, etc., tries to demonstrate precisely that none of us is ready to accept that sovereignty emerges merely from efficient power, that the efficient power must be underlined by some ideological set of presuppositions. And if we look at the world today and we ask about how do lawyers and politicians think about sovereignty, we see that this is really true. Sovereignty is not just about efficient power, but it's about the principles through which we recognize between efficient power that can be endowed with legal authority, the legal authority of sovereignty, and efficient power which cannot be endowed such authority. But that scrutiny produces awkward results. Taiwan is not a sovereign state in international law. When the Baltic states in 1991 re-established their sovereignty, the first thing that the newly established republics wanted their diplomats to convey to their colleagues elsewhere was that, oh, please do not recognize us, because we are actually the same sovereign that was set up in 1922. It was just that although we were sovereign during the long period of Soviet occupation, the sovereignty was in abeyance. So we are the same thing that existed in 1922, which is what countries also did. They didn't recognize the Baltic states in 1991. And what happened with, let's say, Kuwait in 1990 when it was invaded by Saddam Hussein? Well, international lawyers were adamant that Kuwait existed as a sovereign state, even though there was no effective Kuwaiti power in existence at the time. And what about South Ossetia, Abkhazia, Kosovo, or Palestine? Where is effective power? Is effective power the criterion of sovereignty? No, all of these examples tend to show that effectiveness may or may not be part of that specific vocabulary, but it can't be the only part of the vocabulary. So Carl Schmitt cannot have secured a final victory over Kelsen. But what then are, if sovereignty is dependent on criteria, normative criteria, what then are those criteria? Well, people would say from 1919 onwards that self-determination is the criteria, that a community can or must be regarded as sovereign to the extent that the community realizes its right of self-determination. That's a revolutionary, French revolutionary idea also, which then was a big part of the ideological scenery of decolonization and the new international economic order, permanent sovereignty over natural resources. But what people has that sovereignty and what hasn't? In every relevant dispute over sovereignty in the world today, and I suggest always, has been about contending sovereignties when different groups of people want to draw the lines of their communities in different ways and claim that what lies inside those lines is the right sovereign. So as self-determination experts have come to acknowledge, the sovereignty based on self-determination cannot be a consequence of internal criteria. So if I declare here myself as independent sovereign, independent from Finland, that is to say, which I very often think it would be a good idea, it would not be taken very seriously. So there must be some external normative criteria. And what are those normative criteria? Well, I already mentioned a group of actually existing situations. Taiwan, the Baltic states, Kuwait, 1990, Abkhazia, South Ossetia, Kosovo, Palestine, you name it. It seems to me that sovereignty is a matter of performance. So who is able to perform in such a way that others recognize that the performer is a sovereign? Well, but performances are made towards audiences, and audiences differ. And so obviously some people or some communities can be regarded sovereign by other communities, whereas again, those might not accept a further community as sovereign in itself. Sovereignty remains a problem. It's not something, I suggest to you, that can be fixed. It cannot be fixed as a set of ideas, because we always have to ask the question, well, why would those ideas be effective? And it can't be about pure effectiveness of something, because we always ask the question, why that effectiveness should be acceptable, the distinction between mafia regime and a state, for example, which creates this series of deferrals. We, from the present diplomatic situation, try to refer to history. How have sovereign powers been distributed? History refers to law. There are legal arrangements through which this distribution is made. Law refers to facts. It's de jure de facto. Facts refer to ideas about facts that refer back to the effectiveness of those ideas, that refer again to audiences that think about the acceptability of a certain set of effectiveness, and so on. So I suggest, and here is where I end, sovereignty cannot be resolved by speech. It is the condition of speech. It opposes the question of the authority of the speaker. Who are you to claim that you have sovereignty? Or who are you to say that it's up to you to accept that other person's sovereignty? Thank you.
So we have time for some questions. Please, while you're thinking about questions, I will ask a question to get us started. And then I hope Questions will be coming forward from the floor. I just want to reminisce for a moment about the 1990s when the European Union was capturing the imagination of so many lawyers, and so many thought this is the future of sovereignty for the world, in whether we had actual reason for needing to understand all the details of European customs laws or not. We were trying to learn what this European law was because we thought this was the structure of things to come. It hasn't quite worked out that way for the rest of the world, but there was a vision of a change in the form of sovereignty. And one hears today a lot about concerns over the change in the form of sovereignty. I'm thinking particularly about questions of the post-war conception of the illegitimacy of acquisition of territory by conquest, which could be totally conquering your neighbors, or could just be conquering the parts of your neighbor's territory that you would like to have. A number of countries have been considered as actively promoting this. I'll mention Russia and China, but I'll also say the United States has not been blameless in this, particularly in recent years. And I wonder whether this is also a significant possible transformation in sovereignty, or is this just the factual details, and it's all fitting into the same kind of paradigm and dynamic that you're talking about?
Thank you. Yes, so I think it's really useful to make a distinction, as you did, between factual details and the idea of sovereignty. And the way I now think about sovereignty, I usually with students and colleagues, I use this maybe obscure expression, sovereignty as a platform for struggle. So sovereignty is a specific vocabulary. It's a vocabulary that gets its most significant meaning in moments of struggle. So in the Ukraine-Russian war, for instance, sovereignty, the question of sovereignty of disputed territory is at the heart there, and sovereignty becomes a hot topic in that struggle. On the other hand, it's also about precisely the circumstances in the terrain there in Donetsk and Luhansk and Crimea. They are special situations in which both sides, for one reason or another, feel that the claim of sovereignty is really important to make in relationship to that. Now, I come from a country that 70 years ago lost a sizable amount of its territory, Karelia, to the Soviet Union, and the thing is completely cool. Nobody, so there's no struggle. There's the Karelians were settled, who escaped from there. 400,000 of them were settled in the west part of the territory, and there's enough time has passed for the generations thereafter to have forgotten that territory, which doesn't mean that it couldn't rise again, but I do hope it doesn't. Sovereignty as a platform of struggle receives a different meaning and becomes hotter or colder depending on where you use it. The European Union, it's true, as you said, that in the 1990s there were a group of integrationists who were really, how would I put this, playing with the idea of European sovereignty in the European Union. And and we all lawyers learned to make this distinction between sovereignty and sovereign powers. So of course we are sovereign, but they have our sovereign powers. We donated them because we are sovereign, but they have the powers. So that is a way to make us hot topic cool, because it kind of suggests that no worries, we can coordinate this thing. That requires that there's no war, obviously. That requires that there are bureaucratic interactions between people in Brussels and the various European capitals, that you deal with very routine matters, that it all becomes something else than the kind of context in which issues such as are in question in, let's say, to make a random example, Palestine are at issue. So the historical and sociological world changes constantly, and sovereignty becomes more or less important by reference to those changes, to the extent that things feel hotter or colder. Some years ago, I promised myself that I won't mention the name of this Nazi in my talks any longer, but especially when one deals with this question, sovereignty, one cannot avoid mentioning Carl Schmitt's question. And when Schmitt speculated on whether international law can be applied and in which kinds of situations it can be applied, and which kinds of situations are such that have to be resolved by the sovereign nation itself, he said that this cannot be decided by any general rule, because whether something seems to be so important that it involves sovereignty is a matter of the feelings of the people in relationship to that subject matter. And people's feelings are fickle, as we learn, for good and for bad. Right. Okay, so any other questions? Yes, please.
Could you say a bit more about how closely related your idea of sovereignty is to Carl Schmitt's? Because when you said that your idea is that it is a certain performance that has to be recognized by a certain group of people, and you do not make any other normative assumptions, it seemed to me as if it's rather close. It's just a different group of people that need to recognize this performance. Schmitt is the people who have to recognize a certain actor as being the one deciding on the Ausnahmezustand, and in your case, which includes the international law perspective more, it's a group of state actors, but there's also no normative, substantial normative criterion
Well, there was a time in the 90s when mentioning Schmitt's name meant that you were labeled as a Nazi, and that every postmodern thinker actually is a closet Nazi. Fortunately, that time is gone. I would say I'm as influenced by Schmitt as I'm influenced by Kelsen. And I actually think that they agree on the essence of the nature of sovereignty. Yes, I'm not putting forward any substantive criteria. How could I put such criterion forward, and why would it be interesting for you, whatever my predispositions or desires or policies are? I'm interested in analyzing the uses of the notion of sovereignty as it emerges in a number of paradoxical contexts in my professional life and in the professional lives that is familiar to you as well. But I'm also, I suppose one of my hopes is that the question that international lawyers could get rid of the idea that that sovereignty is either bad or good. That sovereignty is, it's a vocabulary that indicates the intensity with which people deal with some problem of the world. It will be there, and I'm not neither condemning nor endorsing that. And I can easily imagine myself in respect of a specific set of circumstances endorsing the sovereign rights of this or that group, or the sovereignty of this or that community. But that's not my agenda today.
Hi, thank you very much. You mentioned Kosovo, so I wanted to ask about the advisory opinion on finding that there was no general prohibition in international law against the unilateral declaration of independence, and whether you think that tells us anything about what the International Court of Justice thinks about sovereignty.
Well, yes, I'm sure it says things about the ICJ, what the ICJ thinks about sovereignty. So in the first place, it says that the ICJ wants, as far as possible, to avoid saying anything substantive or positive about sovereignty, because, as you said, the advisory opinion was formulated in very open-ended terms. So there is nothing to prevent a group of people from advancing towards sovereignty. The Kosovo case itself, I think, is a good example of a hot situation where different sides, both inside the Balkans and the supporters of both sides, so the Serbians and the Kosovo Albanians or the Kosovars. So they both have very powerful groups of supporters, and they see this as a matter of great political importance, and would not want the International Court of Justice to give substantive criterion as to whether or not some entity is entitled to sovereignty. My sense is that in Kosovo, as well as in these other situations, the dialectic, if you want to call it, between effectiveness, if the situation of effective power in some community, as well as the general acceptability of that situation, come together, and then you try to play with these two criteria, some normative criteria, some effective criteria, and hope to combine them in such a way that the audience, whatever the audience is, will find that combination somehow plausible or workable. And the distinctions between de jure and de facto sovereign, for instance, which are very familiar to lawyers since Bartolus. So that's always available for lawyers looking for a middle way between full acceptance and full rejection.
So you described sovereignty as a matter of performance, and then this creates the question within me that would you place all the ascending and descending arguments, international law arguments that are generated during the process of creating the legal arguments and the claims over sovereignty as being generated because of the sovereignty being the ultimate objective, like as international law being generated in view of these claims of sovereignty? Or would you consider this performance as within the broader context of international law, but definitely not the only performance of international law? So would you place international law under the sovereignty claims that international law has been created in view of these sovereignty claims and to serve these sovereignty claims? Or are these sovereignty claims only one aspect of international law, but definitely not the only one?
Well, we've dealt with that in class a little bit. And so my sense is that the power of the sovereignty claim within international law as a doctrinal system, as a discipline, really has to do with colonization. And that so sovereignty emerged as a very large word in the context of late 15th and early 16th century with the Spanish occupation of the Indies, or the conquest of the Indies, and then very strongly in other colonial contexts, especially to make the distinction between communities that are sovereign and those that are not sovereign. And in my own historical work, I've come to the conclusion that if the Europeans would have continued to deal with each other, they could easily have continued to deal with the various different types of communal relations that existed in Europe in the late 15th and early 16th century, with the municipalities, with provinces, with kingdoms, with republics, with towns, etc. The legal landscape was way more complicated. You needed sovereignty in order to make a distinction between sovereign, civilized, developed countries and uncivilized, etc. So that's one thing. The second thing is that in the late 19th century, when the modern international law got its form, then the men, of course, they were all men who were responsible for these early documents and early developments. They were really internationalists, and they felt that the 19th century nationalism, which was often turning, especially towards the late 19th century, turning towards violence, was really dangerous, and that you needed to somehow get away from the the dangers of destruction that the Franco-Prussian War, for instance, 1870, 1871, had shown that modern states have. But they had to integrate sovereignty because they wanted to speak to political people who were political people within states and who were looking for state power and wanted to govern through the state. So that, I think, in the 20th century and up to our day has given sovereignty this ambivalent sense that on the one hand, as an international lawyer, you pray to the god of sovereignty. On the other hand, you speak publicly against the excesses of sovereignty and against nationalism and in favor of internationalism and binding force of human rights treaties and etc. So to be an international lawyer is to be skillful in doing that. So saying both yes and no at the same time and getting away with it.
I think we have time for one last question.
I can just speak up if, yeah.
Oh, so maybe no. Oh no, it's the mic.
Okay. Hello. So the question is, let's forget international law, international lawyers for a second, evacuate them. How the structure of your talk would be exactly the same if you talked about liberty or about any of the property or this type of concepts. So the question from me is what makes sovereignty so special to warrant a particular type of attention or particular type of argument that would be different from discussions about individual liberty, for example?
Or you might want to say, well, actually, Koskenniemi here is wanting to talk about the liberal world order as a whole, as an intellectual and political and economic whole, but he just hides it in an international legal jargon and in his professional capacities as an international lawyer. And I would say that would be one interpretation of what I'm going to do. But I also want to say that sovereignty, if you are in the business of doing international law stuff, so you have to deal with this notion, and you are constantly invited to either endorse it in some full-scale way or then reject it in some full-scale way. And I'm just speaking to my colleague in terms of, well, don't go either one of these ways. Try to understand that it is, as I say, a platform of struggle in which in different situations you might want to need to take a different position. And every diplomat out there in the world is a representative of a sovereign nation, and as such, they have two instructions embedded in their brain, even if not expressly, nevertheless always, at least implicitly. Namely, first instruction, always act in such a way that the sovereignty of your country is strengthened or maintained. And second, always act in such a way that the potential adversary's sovereignty is weakened and eroded. And once everybody around the table has those two ideas in their head, you can understand how complicated diplomacy is.
Please join me in thanking.